कह रहे वहाँ पे एक जज है, यहाँ पे दो तीन है, तो आपका क्या कंटेंशन ये कितना?
I don't, and perhaps there is perhaps one logic behind it. It's not a
No, it is
judicial,
Article
it's only an
184.3.
administrative.
One Article 184.3, the committee will decide whether it is a case of public importance or not. In case they reject, in case registrar rejects the appeal, then the appeal lies in chamber to a single judge of the Supreme Court. ठीक है? यहाँ पे अगर कमेटी ने रिजेक्ट कर दिया, उसके बाद फिर वो कोई रास्ता नहीं है उसके लिए. वो फिर जो कमेटी has rejected, then there is no right of appeal unless we will read it down.
Yes, yes, that is.
आप कह रहे वहाँ पे एक जज है, यहाँ पे दो तीन है, तो आपका क्या कंटेंशन ये कितना?
I don't, and perhaps there is perhaps one logic behind it. Because Article 199 की जो jurisdiction है, that is available, the remedy is available to me as of right if I am an aggrieved person, etc. जो 184(3) की जो jurisdiction है, that is a discretionary. Sir, एक minute.
नहीं तो यहाँ जो अपील आएगी ना, it's not an appeal deciding a list. It is only deciding the competence whether it should be heard or not. Otherwise, the list will remain alive. You can take it in a suit, you can take it in a writ jurisdiction. I don't know, whichever way you want to take it, but we don't kill the list. I mean, it's okay.
Exactly.
You don't meet the test in our opinion. That opinion, your point is that if one judge can get it wrong, the registrar gets wrong, you have it before one judge.
still go
Here the three judges get it wrong. So
and because your lordship will appreciate that when I come in 184(3), I can show to your lordships that I have. Sir, let me just complete this and then I can show to your lordships that I have a case of great public importance.
How are you
It
reading
engages
this right in
fundamental
section
rights,
5?
But your lordships may still
See, how
decide
are
not to
you- how
entertain
are
it
you-
and send me back to the High Court.
How are you reading this right in section 5? Section 5 says, by an order of a bench exercising jurisdiction under 184(3). So how are you reading the right under section 3, that if you are denied, that case is not fixed, that appeal will come under section 5? It doesn't come under section 5.
I'm not reading that, Your Ladyship. I was talking about the fact that an administrative gatekeeper was present under the old system for 43 years, and it is present.
Mr. Salahuddin,
There is an administrative power
Please
being
read
exercised.
section 3.
Please.
Please read.
Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under section 2 for examination. And if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by chapter 1 of part
Please
2
stop here. There are two conditions precedent. One is case of public importance, and the other is the infringement of the fundamental rights. And if this is decided by the committee, and finally it is said that it is a not fit case to be entertained under Article 184(3) of the Constitution, and the person goes to High Court under Article 199, and thereafter, if appeal comes to the Supreme Court, that would be against the order of the High Court under Article 185.
yes.
It would not prejudice the case of that person, and because of the reason that already opinion has been given senior judges of the Supreme Court.
Lord, my humble submission is it would not prejudice the case of the petitioner because it is merely an administrative decision. It is not just like the single judge in chamber.
On judicial
His
side-
order has no judicial precedential value.
Within the
Mr.
parameters of
Salahuddin,
184(3).
on judicial
ये
side, there
पार
are
जो है ये रजिस्ट्रार जो पार एक्सरसाइज करता है that is an administrative power. The three-member committee would also be exercising that same powers. Previously they were being exercised by the registrar, now they'd be exercised by three judges. But there is a judgment of this court which says no. The question whether it is a question of public importance involving fundamental rights, it is a judicial question and has to be judicially decided. How do you answer that?
Lord, my submission would be that even after that judgment, and I think it's 1997 वो PIA वाली
नहीं, recent
recent भी तो है already.
एक से ज्यादा जजमेंट है
जी जी बिल्कुल बिल्कुल.
ऑफ अपील इन चेंबर,
But
इसमें कहा गया कि the word used in is adjudication, the very word used over here. This is a matter of adjudication.
Those
That
were
is a judicial power.
those were orders. The more recent ones are the orders passed by my Lord Mansoor Ali Shah in as single judge sitting in chamber,
one
which
of
is an
them is
administrative power.
one of them is even-
But there are judicial findings of this court also on this, and I think that case relates to
Section
1998.
three-
But all I'm saying there is, sir, that despite that,
What is
the
the solution?
administrative gatekeeper has continued for after that judgment for 23 years.
वो छोड़ें, हम तो एक्ट को
And
देख रहे हैं.
there is
तो आप तो हमसे कह रहे हैं कि हम उसको एक्ट में कंटिन्यू करते रहे.
my lord,
थोड़ी
it
सी
has
दिक्कत
not,
नहीं हो रही
all I'm saying is it has not, that aspect has not previously troubled
Yes, but
this
there is a
court
slight
so long
difficulty
as it
here.
was done by the registrar.
सलाउद्दीन ये जो रजिस्ट्रार के ऑर्डर के खिलाफ अपील सिंगल जज को है, ये अपील की रेमेडी बाय रूल्स प्रोवाइड की गई है।
जी सर।
और इसी तरह ये जो कमेटी बनेगी सेक्शन 3 में, ये भी तो एडमिनिस्ट्रेटिव कमेटी, इसके खिलाफ भी रूल्स में
अगर रूल्स में आप एक अपील दे दें तो that
प्लेटफॉर्म
would
दे
be
सकते हैं, देयर नो प्रॉब्लम।
बिल्कुल बिल्कुल सर, बिल्कुल। और
अजीज साहब खत्म।
I'm done, sir. As for sir, sorry, one last aspect, and that relates to the question that Her Ladyship Aisha Malik had asked. What is the effect in Section 5 when if a full court is formed or a 9-member bench is formed, etc.? I would rely upon the principle that there is a difference between a statutory provision that is ex facie discriminatory and a provision that may only be applied in future in a discriminatory fashion. The distinction is drawn in Jibindra Kishore, that is PLD 1957,
It's
Supreme
not a
Court.
question of discrimination. It's a question of the right of appeal being taken away, full stop.
Yes, that issue also I'll cover. But first of all, जो discrimination वाला aspect है, because Article 25 was said that one person is being denied the right of appeal just because a committee has formed a larger bench. So the other judgment is Shaukat Ali Mia,
It's not
PLD,
just a question of
PLD 57 का
discrimination.
citation क्या है?
PLD 1957, Supreme Court 9, and PLD 1999, Supreme Court 1026. That's Shaukat Ali Mia.
It's not just a
You have to
question.
repeat this. It's 95 Supreme Court,
So 99 Supreme Court 1026.
1026. और
शौकत अली मियाँ का केस सर, वो जो फॉरेन एक्सचेंज
जी जी पहली
वाला।
कौन सा
पहली जिबिंद्रा किशोर का था सर, PLD 1957, सुप्रीम कोर्ट पेज 9.
Okay.
My question was not only of discrimination, but my question was that it is a substantive right that the law provides. And if the law is to be upheld, then on what basis can the committee deny any person that substantive right? So it's not just a question that some will be allowed and some will not be allowed. The question is then that actually you cannot make a full court or a larger bench because that right of appeal will be denied to a person. And there is no basis to deny a substantive right.
The solution that I will offer, and then I will rest.
Solution तो बाद में आएगा ना, पहले तो जवाब होना चाहिए कि ये हो भी सकता है कि नहीं, फिर solution आएगा.
The answer that I will offer.
You see, the thing is, in practical terms, the 3-member committee, essentially that committee would decide in which cases an appeal would be available and in which it won't be. Because by constituting a bench more than 8 judges, it would deny the right of appeal. And by constituting a bench of less than 8 judges, it would provide a right of appeal. And what is the criteria here?
I would therefore-
एक second. Again, there are two concerns. One is the past, one is the present. If this law is sustained, then naturally the committee will realize the provision of an appeal and will make an attempt not to do 9 benches plus, okay, realizing that, unless it's a matter of, I don't know, I don't want to state it because it may come to haunt me, but having realized that, so as far as the past is concerned, that's a different matter altogether. So committee being cognizant of this law will try that in 184.3, we do not go and constitute 9+ benches, or if you don't have enough judges to hear an appeal. That's a simple answer. If the committee wants to close its eyes to it, that's another thing. Then you will say that the fault does not lie in the law, the fault lies in the committee and
in the
your
discriminatory application of that law.
Yes.
Now that is why I was citing
by
these
that
judgments,
token,
because these judgments say,
for all intents and purposes, a full court and 184.3 can never be made.
sir, मैं,
Yeah, अब इसका take this case for instance, इसकी अपील चलें, हमने कहा ये दो ही हो सकते हैं ना, असिस्टेंट करें, स्ट्राइक डाउन करें, कुछ लोग खुश नहीं होंगे, अपील कहाँ होगी? तो एक सिंपल जवाब है, नहीं होगी भाई, सबने सुन लिया, क्योंकि जिसने अपील सुनना था वो भी बेंच का हिस्सा थे। अब खत्म करें बात को।
जो जजमेंट्स मैंने साइट की थी वो ये कहती हैं